Hello and welcome to BloombergQuint. We're here to look at what happened in the Essar Steel case after 2.5 years of an insolvency proceeding going on. Now, a three-judge Supreme Court bench has just delivered its verdict in the Essar Steel insolvency case. The judges have said that the right of distribution of claims is with the Committee of Creditors and not with the NCLAT or the NCLT. That while these tribunal benches can resend the plan back to the Committee of Creditors, they're not allowed to change the effective plan. Now, just for some background, the case was essentially there was judgment in the by the NCLAT in July 2019, where the NCLAT said that all classes of creditors would get about 60.7% worth of recoveries of whatever their exposure is, and that the financial creditors have opposed it and said that their plan, the assessment and the allocation of funds that they had done earlier that year, should be the right way of looking at it. Now we have on the phone line with us Mr. Nilang Desai, partner at AZBN Partners. Nilang, just your initial few views after the Supreme Court has now ruled in favor of the Committee of Creditors.
I mean, I have to say that we need to look at the text of the judgment to make more sense of it. But in principle, that sounds like a very sensible precedent to go by, and something which we think that the founders of the IBC and in the BLRC really intended for the COC to make the commercial decision and for courts not to interfere in commercial decisions. So, I mean, from what you're telling me, this sounds exactly where we need to be going. Right. But we'll have to see the fine print, of course.
Right. So just to get a sense of, the legal implications of what the NCLAT judgment had meant, till this point in time, that was the only legal judgment that we had, and how the NCLAT was looking at, say, equality amongst different classes of creditors, and now the Supreme Court is saying that that principle is flawed. So, your views on that?
Well, I have to say I'm not sure I was in support of the judiciary coming out to determine what distributions should be from a resolution applicant. So if this is what the Supreme Court is saying, I much prefer the Supreme Court view and allowing the commercial minds to make a commercial decision, subject, of course, to equity being maintained.
Right. And by equity, what do you mean, Nilang? Because just to get a sense, if that is the core of this argument, that equity and equitable distribution, how do you differentiate that?
I don't think one needs to differentiate. I think they hold well together, actually. I think the angle should be that while you're being commercial, these are the principles which must be laid down to balance equity. And those principles have been laid down in the Amendment Act a couple of months ago.
Right, right. We also have on the phone line with us Sitesh Mukherjee, partner and head of disputes at Trilegal. Sitesh, just to get your initial view on the Supreme Court's assessment that the Committee of Creditors has all rights to take a commercial decision, and the NCLAT or the NCLT is not empowered to dispute that or to change the plan essentially to ensure better allocation of funds in their minds. Your initial views?
Yeah, I think, in my view, it's a very fair judgment. It has allowed, of course, judicial review of the Committee of Creditors' decision, but those are on very limited grounds to ensure that the Committee of Creditors maximizes the value of the corporate debtor, and also to ensure that the Committee of Creditors balances the interests of all stakeholders. Right. The reasons given by the Committee of Creditors for approving the plan are subject to judicial review only on these limited grounds, and otherwise the commercial decision has to be allowed to prevail. That is what the Supreme Court has said with regard to the nature of judicial review over the decision of the Committee of Creditors.
Right. Sitesh, also this point, now they've made a statement on the 330-day timeline that was finalized in the recent amendments of the IBC. What they're essentially saying is that here again, this is not a mandatory timeline of 330 days to resolve a case, and that the tribunals the adjudicating authority can extend time in what they call exceptional cases. We're not sure how they define exceptional cases, but just to get a sense of, earlier we had a 180 plus 90, that obviously was not being met in a lot of cases. Then that time got extended to 330, and now even 330 is not mandatory. How do you see this for future cases?
So But I do think that in commercial matters and matters like this, time is of the essence, and it is equally important as the money in most cases. But you see, there are 3 layers of court process that this IBC resolution has to go through. And one of the things that the court spelled out in pronouncing its decision is that sometimes the legal process can be tardy. And in such circumstances, the corporate debtor or the lenders cannot be blamed. And in exceptional cases where a little bit of time is left, or where the court process has been tardy, and and therefore equities need to be balanced, and the lenders and the corporate debtor should not be made to suffer on that account. All efforts should be made to put the corporate debtor on the feet. So accordingly, the word mandatory in 330 days has been set aside, and parties can apply to the adjudicating authority or the NCLAT for extension of time on the circumstances that have been listed. But again, I think it is going to get confined to the the delays in the court process, and that is something which is genuine. While the delays in the court process needs to be trimmed, but that's an inevitable fact of life in the Indian system.
So far we've not heard anything about what the Supreme Court thinks of the whole Standard Chartered issue, because that's where the financial creditors had made a distinction between a secured financial creditor versus an unsecured financial creditor. Just to get your sense, the NCLAT was of the belief that that should not be the case, and they were allowing more than 2,000 crore worth of repayment to Standard Chartered. But now, to your mind, is that important even under insolvency to differentiate between these two classes of creditors? According to banks, unless you do that, you're risking the whole lending system.
Of course, it is very important to do that in the insolvency process. After all, the security that have been given are the basis of the lending transactions. It will upset the whole banking system. And to my mind, and I got this from what the court spelled out, is that they said there is no principle of equality which is there between secured and unsecured creditors. And I think secured creditors are being prior to that of unsecured creditors has been upheld in this judgment. Because I heard a line where the court pronounced that there is no principle of equality between secured and unsecured creditors.
Got that, Sitesh. Let me go back to Nilang Desai of AZB Partners. Nilang, to your mind, this question of whether a secured and an unsecured financial creditor needs to be looked at the same way or looked at differently, how do you look at that? And secondly, how important is it to ensure that future lending is dependent on these precedents?
I think about a year ago when I was talking with one of your colleagues at your studios, I had mentioned this, that to look at secured and unsecured in the same way is a bit of a disaster, because how does one go into a fresh lending into a company, assume that security covers you, and then find that when assets don't match liabilities, actually you're at par with unsecured? What's the point of security then? I think it destroys the basis of new lending. I don't think it works with reason. And therefore, by definition, you must look at secured and unsecured lenders differently. If you've gone in as unsecured, you've gone in eyes wide open, you've gone in with a different margin, with a different profit expectation, presumably, or because you think that the liquidity of the company is going to go in a certain way. Now, if your bet has failed, why should you get the same amount of money as someone else who is conservative and sensible?
Fair enough. Nilang, there's also this argument that the financial creditors had presented in court, which said that over the time that this case has been under insolvency, they have not been paid. Obviously, there was a moratorium on their dues, as opposed to let's say an operational creditor. I think we've just lost Nilang, but let me pose a question to Sitesh. There is this argument that operational creditors have been paid over the last 2.5 years, while financial creditors have not, and therefore this argument that operational creditors are being are being denied their rights, that probably doesn't stand. Would you agree with that?
Well, I would not like to comment on the specifics of this case because I'm not fully aware of the facts. But I would like to say that, the court has observed that, the operational creditors' interests have to be taken in by the committee of creditors. and they cannot be left high and dry. And that is one of the points on which the process of judicial review can happen.
Sure. Just to get a sense of, now it's been, to be fair, it's been 2.5 years for this case to finally reach some sort of a closure, and finally this takeover of ArcelorMittal, or takeover of Essar Steel by ArcelorMittal, that being approved. What does this mean for, let's say, larger resolution, that strategy and that whole process of resolution of large assets that is being done under IBC?
I think this case has raised so many issues and which have been sorted out in very quick time by the apex court that, it leaves less room for delays in future cases like this. So it was a test case. It was one of the biggest cases. And it took some time to come through our court process. But once the principles have been established by the apex court on numerous occasions dealing with this case, I think in future cases we will find it easier to, shorten the timeline and carry things forward more quickly.
Right. Also, the point about this Section 29A, now that obviously also got tested quite a bit during the hearings in this case, whether a promoter can in any form come back. I mean, even though Section 12A exists for a promoter to go out and resolve the case bilaterally with the lenders, but I think the principles of Section 29A got tested and now have come out clearer as to how you should be approaching some of these cases in the future.
Yes, the Section 29A principle also has been, clearly commented upon and ruled upon by the apex court, and there is a lot of clarity now in the process. So I think that also will tend to be less of an impediment as we move forward in some of the other cases.
Right. Lastly, Satish, if you can get a sense of where exactly now this whole situation lies. I mean, as of now, as things stand, the lenders can go ahead and deal with ArcelorMittal and finally close the entire deal. Is my understanding correct?
Yes, that would be correct.
That would be correct.
The judgment has paved the way for the lenders to go ahead and close the deal.
All right. So that was Satish Mukherjee. Let's take you through, what exactly has happened in these 2.5 years since Essar Steel was admitted to insolvency. So back in June 2017, the RBI put out a list of 12 large accounts which had to face immediate insolvency. By August, the case was admitted despite some of the promoters' objections to the whole process. Finally, then the promoters went ahead and created an entity known as New Metal in November 2017, which essentially was created specifically to bid for Essar Steel. And in that, there was an entity called Aurora, where there was some promoter linkages. By February 2018, New Metal as well as ArcelorMittal had both bid for Essar Steel. And after that, the lenders had rejected both these bids, citing Section 29A. New Metal's case, of course, the Ruya connection, and for ArcelorMittal, Uttam Galva's outstanding dues. The NCLT in Ahmedabad did not give the bidders their required reliefs, but it did ask the COC to review the bids again before rejecting it. After that, both the bidders submitted revised bids in March 2018. However, the judgment, the case was then taken to NCLAT to look at whether they can go in. Finally, the NCLAT ruled in favor of both the bidders, and they said that unless you clear the bids, you can't really go into bidding for Essar Steel. We'll come back to this in a bit, but we have Mrityunjay Mahapatra, the Managing Director and CEO at Syndicate Bank, on the phone line with us. Mr. Mahapatra, for the lenders, this sounds like a day of vindication for their original stand in the Essar Steel case?
It is not just a vindication. I think it is a reaffirmation of the original intent of the legislature, where resolution in a timely manner was perceived as one of the most, kind of prominent outstanding issues on the efficiency of the financial sector. So Committee of Creditor was given the primacy in determining the distribution, and this has been reaffirmed by the Supreme Court. Also, this being an evolving legislation, and this case being one of the cases which was watched with interest by all stakeholders. I think this clarity for this evolving framework of resolution in terms of what should be done, I'm sure this will go a long way in efficient redeployment of credit, cleansing of the balance sheets, and resolution of large NPAs.
For syndicate banks specifically, what is the kind of recoveries that we're viewing here?
We are looking at around 1,200 crores.
So about 1,200 crores will come back to you, and obviously that money will go into rewriting your provisions and writing back your provisions and obviously lending further. Right. Just to get a sense of, this whole argument of secured versus unsecured financial creditor as well as financial creditor versus an operational creditor, how do you see this, sir? Obviously all the lenders have been in unison saying that secured financial creditors need to be given priority over anybody else. Just to, if you could reiterate your views, sir.
See, the Supreme Court, in its original judgment, when they upheld the constitutionality of the IBC, they told, the current judgment that has come today, I have not read as to what are the clarification that Supreme Court has given, but the sum that has been read out and that has been circulating in the newsrooms of various media houses, it says that it has reiterated. But in the original judgment itself, Supreme Court told that the other forums like arbitration, like the Contract Act, are open for operational creditors, and for financial secured creditor, IBC is the route. I believe that the consensus is emerging around that, and also the fact that the secured creditors in the current case has left out a good portion for the operational creditor. Signifying that it is an objective kind of a distribution will also go a long way.
Right, sir. Sir, also, lastly, on the whole idea of this 330 days not being mandatory, now that the court has said that the adjudicating authority has a right to extend this 330-day timeline if it is an exceptional case. How do you see that for the future of NCLT and how banks approach this route for resolution?
No, as a banker, we will be interested in quicker resolution because we are unable to accrue income on that, and we have a holding cost. So sooner it is resolved, it is better for us. But this particular aspect of the judgment, I'll have to study that whether, in what the Supreme Court, because Supreme Court's decisions are not just decisions, but they are the law of the country. So we will have to find out that what they have spoken, whether they have told that generally it should be faster, but in exception cases, the tribunals can extend it. So whether the 330 days, which was an extension of the earlier 270 days, will be there, or the legislature has to bring in enabling provisions to comply with the Supreme Court law, that Supreme Court pronounced judgment, that we will have to see as the judgment copies are made available.
All right, Mr. Mahapatra, thank you so much for joining us with some of those initial views. We will, of course, reach out to you once the final judgment of the Supreme Court is out in the public domain. We have with us now Arpan Chaturvedi, my colleague from Delhi, who was at the Supreme Court when the judgment was being read out. Now, Arpan, just to get a sense of, how exactly did this play out and what has the Supreme Court said in some of its explanatory parts?
That's right. So this case, apart from looking at whether the winning bid of ArcelorMittal would be approved and how the distribution of claims would be, was also dealing with some important principles of insolvency law, and key among them was what is the position of different classes of creditors in the Insolvency Code. Remember, the Committee of Creditors had argued that the Insolvency Code recognizes a difference between operational and financial creditors, and they had also said that even within the same class of financial creditors, there can be differential treatment depending on the nature of the charge of debt that the financial creditors hold. The Supreme Court, in its judgment today, has said that the Insolvency Code does not recognize or the principle of equality between all classes of and all kinds of creditors is a flawed one. So that in that they seem to have answered those two particular questions that were raised. Now the reasoning behind it will of course be known once the detailed judgment is uploaded. Apart from that, there was also a challenge to the amendments to the Insolvency Code that were introduced, and key among them was the 330-day mandatory period for completion of insolvency which included the time that would be taken for litigation purposes. The court today has held that that cannot be made mandatory. During the course of arguments, the operational creditors had argued that the putting a mandatory period for completion of litigation ventures into the territory of interfering with the independence of the judiciary. Therefore, the court has today said that the 330-day period will not be mandatory, and it will be open for the adjudicating authorities to extend the deadline in exceptional cases. Now, as far as the Essar Steel case specific is concerned, here the court has said that the distribution of claims, the COC will have the authority to decide on that particular aspect, and the distribution of claims will be made in this case as per the resolution plan submitted by Essar Steel, ArcelorMittal, apologies.
Right. Arpan, just to get a sense of, you mentioned exceptional cases. That's when the adjudicating authority has the right to extend the timelines. Was there any explanation of what exactly is an exceptional situation?
That, of course, I think we will get to know once the detailed judgment is uploaded, that whether the Supreme Court has left that completely at the discretion of NCLAT, or have they put out specific guidelines as to when or what cases will qualify under that exceptional guideline. It was a very short judgment that was read out in court. So the details of that particular aspect, of course, we will get to know once the entire judgment is uploaded on the top court's website.
Arpan, thank you so much for joining us, and we will of course get back to you once the final judgment is out for more details. And that was my colleague Arpan from Delhi. Just to give a sense of where we stand at this point in time. So earlier we were explaining how this case has reached where it has reached. So in July 2019, we had a judgment by the NCLAT which essentially said that all creditors will be given a 60.7% recovery rate, while the lenders at Standard Chartered would get a higher payout than what was originally decided by the COC, and as well as the indemnities as well as guarantees issued by the Ruya family, those will get extinguished once the case has been resolved, because the underlying loan does not exist. The lenders, of course, had opposed that, saying that while the case has gotten resolved because of ArcelorMittal's payments, the lenders have reserved the right to chase the promoters for further payments. Whatever is being written off in the form of a haircut, that can be recovered from, or at least recovery proceedings can be initiated against the promoters for it. Now, clearly, the judgment is very clear. Yeah, it just as well as the judgment very clearly says that all decisions by the COC, commercial decision by the COC, is their own right, and the adjudicating authority cannot intervene in that final sort of decision that is being made by the COC, and they cannot obviously change the way the plan has been constructed by the COC, as well as a clear statement from the Supreme Court which says that there is no the whole idea of the equality amongst different classes of creditors, that itself is flawed, and obviously that how people in the system are reading, lawyers as well as bankers, how they're reading it, is that the Supreme Court has given that hierarchy and ensured that secured creditors get their due first, and the rest of the other creditors, which is including of unsecured creditors, financial creditors as well as operation creditors, they will get their dues depending on how the allocation is being decided by the COC. So clearly those issues have been put to rest. We still do not know what the Supreme Court has said about the whole idea of guarantees as well as indemnities of the Ruya family, and whether the lenders can proceed against the promoters in those cases. That will probably get clearer once the final judgment is uploaded. But as of now, the lenders have clearly gotten what they wanted, and the case will go ahead as planned. ArcelorMittal will be taking over Essar Steel and pay the COC about 42,000 crore for it, and the distribution of those 42,000 crores will be decided by the Committee of Creditors, and only by that measure. Clearly, that is the news of the day. Essar Steel getting resolved after 2.5 years of spending days in court among a lot of litigation, either by promoters, operation creditors, or by the lenders themselves, and finally seeing the light of the day. So that's all we have for discussions at this point in time. Once the final judgment of the Essar Steel case is out, the Supreme Court's final verdict is out, that is when we will come back and try and discuss more, as well as discuss this with some of our guests. Till then, do keep watching BloombergQuint for further updates.